Hi, I'm attorney Gregory Dell here with attorney Alex Palamara, and today we want to talk about our extensive experience in handling disability insurance lawsuits against the Prudential insurance company. Now, Alex, we've handled lawsuits against Prudential all over the country, literally as far away as Hawaii, New Jersey, New York, Massachusetts, Texas, California. I mean, all over the country we filed lawsuits against them. We've been doing this for more than 20 years, and clearly we know everything and anything about them. But let's educate people who are now found themselves in a situation where they've exhausted all of their remedies, meaning filed all of their appeals. And Prudential, you know, they have to do one mandatory, then they can do a voluntary appeal. Some people do that, some don't, and we've always rendered difference of opinions as to whether or not that's worth it. But where are we at now? Everything's done. Administrative remedies are done. What are the steps to be taken now in order to file a lawsuit is what I want to talk about. And then we'll move on to expectations for time frames for a lawsuit, and then potential outcomes we'll get into. So let's start with appeals. You know, appeals been denied. That's why most people probably found this video. What are the first steps we're going to take for them?
Well, filing an ERISA lawsuit, I hate to be the bearer of bad news, but ERISA laws and ERISA lawsuits, they're difficult. The laws are written in favor of the insurance company, and lawsuits are difficult to win. But if you do the right process, it gives you the best chance at proving to any judge that Prudential's decision was incorrect. The first thing you need to do is order a copy of the claim file from the insurance company. The ERISA laws mandate that they have to provide this to you upon a denial of your claim. And the first thing you should do is request such, and they have 30 days to get it to you. And once you receive that claim file, it's going to be a long document, anywhere from hundreds of pages if the claim is relatively new, to thousands upon thousands of pages if a person's been on claim for years. So the first thing you need to do, obviously, is order the claim file. The second thing you need to do is review that claim file.
Okay, so in terms of the courts, I mean, these obviously go into federal court because it's governed by ERISA. A lot of inexperienced lawyers try to put these things in state courts. Because it's a federal law, we're able to file them in just about any court in the country, although there's some case law talking about which particular courts you can go into. However, we're always going to go into the best court that we think's in the best, you know, to get the best outcome for our client. But important for people to know that we can file it anywhere. It doesn't matter where you live, that our law firm is going to be able to handle that lawsuit. So that shouldn't be a concern at all. What do you find is the average time frame from when we file the lawsuit until it gets completed?
Well, completion can be, there's the various levels of completion. Completion could be a settlement, and a settlement can take a matter of weeks sometimes. So I filed a lawsuit, and the attorney will contact us immediately, say, send us a demand, and we can actually have a lawsuit settled before they even filed their answer. So sometimes a lawsuit can be filed within the first 30 days. Sometimes a settlement can happen anytime between the time of filing to the time of trial. So typically a trial is set out anywhere from 12 to 18 months from the time of filing. So a settlement can happen any day from day 1 to 18 months out. Typically, most settlements happen at or just before mediation. Now, courts require that the parties mediate, meaning that both sides come together and meet in person with a certified mediator, and both sides come together and negotiate the case at that point. Most cases are settled at or before mediation. Typically, mediation is anywhere from 6 to 9 months from the time of filing. So in most situations, if there's going to be a settlement, anywhere from day 1 to maybe 9 months in. If there's going to be a trial, the case can be wrapped up within 12 to 18 months. On the quicker end, of course, even if you prevail in that lawsuit and the judge finds in your favor, there's always the possibility of appeals in the appellate process, which can actually extend your time until you recover any benefits a little further out or a lot further out.
Okay, one of the things that people think about lawsuits and they go, gosh, it's going to take all my time. I'm going to have to go all over the place and they're going to harass me. That is kind of one advantage of an ERISA lawsuit, is that you're not going to have to do much of anything. Correct. In this lawsuit. That once we file this lawsuit, our law firm is basically going to handle every single thing for you. It's not like a typical lawsuit where they're going to have interrogatories where they can send you questions, requests for production, take your deposition, depose your doctors, depose your coworkers, depose your family members. You're going to have none of those inconveniences. Everything is already done from the administrative record, and the only discovery or things like that with litigation of discovery of depositions and things like that might be of us taking them, of the insurance people over there, but never of you. You're not going to be inconvenienced at all. And the likelihood is you will never appear in court, and especially since, unfortunately, you don't get your day in court in the sense of the ability to give testimony for a judge or for the judge to even speak to you. It just doesn't happen in ERISA. So that's one situation where it's very convenient for the claimant. The other thing you mentioned is that our law firm's ability to get these cases done relatively quickly, as opposed to the horror stories you hear of litigation going on for 3 years. And that's because we've already litigated over 1,000 cases against Prudential, and they don't want to spend thousands and thousands of dollars to litigate. So they say, look, let's try to come to the table early. We know you can make us run around and do everything and make our lawyers spend thousands of dollars litigating this case, but we're going to give your clients the benefit of the doubt and try to reach an early settlement with you in an effort to try to get the case done. And that's assuming that we can get a settlement that's acceptable to the client and eliminates the risk of going to trial. So you mentioned something important. You said most of these cases resolve at a settlement. And that's 100% true. And that's consistent with the fact that 97% of federal lawsuits, no matter what they are, resolve in a lump sum settlement. They just don't go to trial because the risk versus the reward is just way too high. So that being the case, you should not be, a lot of people are so stressed about what's going to go on and how many of these cases go to trial and what percentage of your cases do you win. And we often say, look, we get a recovery on 99% of these cases because number one, we're only going to accept your case if we think we can get you money. That's most important. And number two, since 97% of them are going to resolve in a settlement and only 3% of them go to trial, there's a high likelihood that your case is going to end up in a settlement because, again, when we advise you and you do the risk versus reward analysis, you're probably going to determine that it is not necessarily worth the risk to take the case to trial. And that's all the things that we're going to advise you on. We're going to determine if your case is in the best position possible to win or not. Now, the last thing, what are the remedies if a settlement isn't reached and the case goes through to a judge's decision? What kind of rulings can the judge make?
Well, most of these ERISA insurance cases, they get resolved by way of motions for summary judgment. So there's actually no trial date. Typically, there's not even any oral argument. What happens is both sides file their motions for summary judgment. Then both sides will have time to file responses to the other side's motion for summary judgment. And then after that, both sides have a chance to file replies to the responses. So once all those are filed, and it typically can take anywhere from 3 to 6 months from the time the initial motion's filed before a judge actually gets the final product. And it can take an additional couple months for the judge to actually review everything before the judge issues an order. The judge's order can be a few things. The judge could say, I find that the decision by Prudential was arbitrary and capricious, and I find the person to be disabled, and the judge can award benefits for the claimant. The judge can say, I don't find the decision by Prudential to be arbitrary and capricious. Although I find the person disabled, I don't believe that their decision was necessarily wrong, so I find for the defendant. Or the judge can even just say, I don't find the person to be disabled and rule against the claimant as well. The last thing that the judge can do is remand the case back to Prudential. Maybe there is documentation that Prudential failed to review. Maybe there is... there could be various reasons why the judge remands it back to Prudential, but there's actually 4 options. The claimant can win, the defendant can win even though they did a fine review. The defendant can win because the judge didn't find the person to be disabled, or the judge can remand it back to Prudential. There's 4 options for the judge. And
the remand happens half the time, and I think it's a terrible remedy because it basically gives Prudential another bite at the apple to review the claim. And so look, Prudential is not the easiest company in the world to deal with when it comes to litigation. They will fight very aggressively. I'd say they have a high percentage of the ERISA disability lawsuits around the country in the federal courts. We've participated in a big percentage of those. And we're always tracking every lawsuit around the country filed against Prudential. So if you have a Prudential lawsuit, the first step is send us your final denial letter. We will immediately take a look at it. One of our lawyers is going to get on the phone with you, and within a matter of minutes, we're going to let you know whether or not we think we can help you. We never charge any fees or costs unless we make a recovery for you. And we really look forward to the opportunity to discuss your options and let you know right away from our experience what we think the potential outcome will be for you. Thank you.